Ownership and title. The United States practices what is perhaps the freest and most flexible form of real property. Ownership, which comes with a bundle of rights, possession, quiet enjoyment, disposition, exclusion, and control. Remember that someone can sell all of what they own, or part of what they own, but never more than what they own. Keep those concepts in mind as we continue the discussion on ownership. We'll also consider the transfer of title to real property as we discuss the concept of alienation and describe how title can be conveyed as we look at different types of deeds. Finally, we'll review the importance of the public records and title insurance. First, let's contrast sole ownership and the different forms of co-ownership. Ownership in severalty, also known as a tenancy in severalty, is the simplest form of ownership. It is a sole form of ownership, meaning that only one person or a legal entity, such as a corporation, holds the title to that property. Don't be confused about the word severalty. It might sound as though it implies several people, but it really means that one owner's interest has been severed from the interests of all others. Co-ownership, also known as concurrent ownership, is any form of ownership where two or more persons or legal entities share title to real property, with each person having an undivided interest in the property. Undivided interest gives each co-owner the right to possess the whole property, not just part of it. Under the law, any number of persons may join in the ownership of real property. Co-ownership forms include tenancy in common and joint tenancy. Tenancy in common is the undivided interest in land with no right of survivorship. It is the only co-ownership that can be owned in unequal fractional portions. Tenancy in common is the most common type of co-ownership and can be created and conveyed by a deed or devise, which occurs under the provisions found in a will. In most states, if the language in a deed does not specify a specific type of co-ownership or if the co-owners are not married to each other, tenancy in common is assumed. Joint tenancy may be created between two or more natural persons when each co-owner has an equal undivided interest in the property and the automatic right of survivorship. When one joint tenant dies, the surviving member or members of the joint tenancy receive the deceased person's share automatically and equally. Joint ownership requires the presence of four unities: time, all must acquire at the same time; title, all must acquire through the same document; interest, all must hold equal interests; and possession, all have equal rights of possession. Remember that a corporation, which is considered a legal person, can co-own property as a tenant in common, but never as a joint tenant. Parties to a joint tenancy or a tenancy in common have the right of partition, which allows any co-owner to end the co-ownership. A voluntary partition can be implemented where both parties agree to end the joint venture and divide the property so each owns a piece in severalty, if it can be done equitably. Or, one owner can sue the other through a judicial process to dissolve the co-ownership and divide the property, or sell it and divide the proceeds according to the judgment of the courts. One last form of co-ownership we'll discuss is tenancy by the entireties. Tenancy by the entireties involves only owners who are legal spouses, and it generally includes the right of survivorship. This form of co-ownership is not recognized in every state. Before we move on, a quick caution. Although you may be familiar with these different forms of ownership, your role is not to be a lawyer, estate planner, or tax advisor. You should advise your clients to consult with an appropriate professional about their ownership options. Business organizations, nonprofit groups, and other entities may own property in severalty or as co-owners with other individuals or entities. There are a number of ways in which a business entity can be created and organized, and we'll quickly define some of them next. A sole proprietorship is a business owned by a single individual in severalty where the owner is personally responsible for any business debts. A partnership is an association of two or more individuals as co-owners of a business. In a general partnership, all partners share in the financial liability both individually and as a member of the partnership. A limited partnership includes one or more general partners and one or more limited partners. The rights and duties of general partners in a limited partnership are the same as in a general partnership, but limited partners have no say in partnership matters. The liability of any limited partner is limited to their original investment. A corporation is a legal entity that is owned and controlled by its shareholders. Within a corporation, property is typically owned in severalty as the legal person, but the corporation could be a co-owner of property as a tenant in common. Shareholders are not personally liable for a corporation's debts. A limited liability company shares some characteristics of both a corporation and a partnership. Owners of an LLC, also referred to as members, have limited personal liability for the actions and debts of the company and benefit from pass-through income taxation. A security is an investment that gives an investor a financial interest in a business without allowing any sort of managerial control, such as shares in a corporation. Remember that securities are regulated by the federal government. Some states may regulate securities through blue sky laws. Unless you have a securities dealer license, you will not be able to arrange a real property transaction that also includes the transfer of shares in a corporation. A real estate investment trust, or REIT, is a real estate investment business with at least 100 investors. It's organized as a trust where one or more trustees manage property for the beneficiaries, the investors. In order to avoid income tax, a REIT must earn 75% of its income from real estate and distribute 95% of its taxable income to its beneficiaries. Finally, remember that when working with any business entity, real estate licensees must determine who has the legal authority to sign on the entity's behalf. Today, there are a number of alternative forms of homeownership beyond the traditional, standalone single-family home. A common interest ownership community is one where all of the owners share in the costs associated with maintenance. The most common examples are condominiums and cooperatives that combine individual ownership with co-ownership in both the physical and legal realms. Condominiums are structured physically and legally to combine individual ownership with co-ownership. Each co-owner has a separate fee simple interest in the interior space of their individual unit combined with an undivided interest in the common areas, such as hallways and recreational facilities that all tenants own and use, as tenants in common. Most condominiums also have limited common areas that are owned by all but used by only one owner, such as a balcony or parking space. Property taxes are levied against each individual unit owner. As part of the process to create a new condominium, a developer must record a condominium A cooperative, or co-op, is a building owned by a corporation, where the residents are shareholders in the corporation. Each shareholder receives a proprietary lease on an individual unit and the right to use the common areas. Property taxes on a co-op are levied against the corporation, not individual unit owners. Townhomes or properties developed for co-ownership where each co-owner has a separate fee simple interest in an individual unit, including its exterior and the ground directly beneath the unit as well as an undivided interest in the common areas of the property. This differs from condominium ownership, where the fee simple interest is in the airspace only. A timeshare is a form of property co-ownership in which several buyers purchase interests in real estate, with each party having the right to use the property and facilities for a designated period of time. Remember that someone who owns real property is said to have title to that property. Let's now turn our focus to the process of transferring title, which is called alienation. Title to real property may be transferred during an owner's lifetime by voluntary alienation or involuntary alienation. Voluntary alienation is the most common way to transfer ownership of real property. Voluntary alienation is an action that the property owner takes of their own free will. The most common example of voluntary alienation is an owner who agrees to sell the property, handing over title in exchange for consideration. This is usually completed with a deed. Other types of voluntary alienation include the gift of a deed, the dedication of private property for public use, or the grant of title to property from the government to an individual. Involuntary alienation, on the other hand, is the transfer of title and an interest in real property against the will of the owner, or without action by the owner. Some examples of involuntary alienation include enforcing liens through foreclosure, adverse possession, condemnation through the power of eminent domain, and even natural forces. Natural forces include avulsion, which is a sudden process where land is violently torn away by flowing water as in a flash flood, or accretion, which is a gradual addition to dry land, such as when a river deposits waterborne. Acquiring title to land by adverse possession requires open and notorious, hostile and adverse, exclusive, and continuous use of another's land for a period of time as defined by the laws in each state. Title to large parcels of property through adverse possession is very uncommon. It's more likely to come into play over a disputed property line. Eminent domain is the government's constitutional power to take private property for public use, such as for roads, fire stations, or landfills, as long as the owner is paid just compensation. The actual act of taking private property for public use through eminent domain is known as condemnation. The real property of someone who has died with a will, meaning they died testate, is transferred through devise. Property transfers through descent when someone dies without a will, a situation known as intestate. If a property owner dies intestate and there are no heirs or creditors, the property would revert to the state through the process of escheat. As mentioned, a deed is the most common means for conveying ownership in real property. The grantor is the person who conveys their interest in the real property, while the grantee is the person receiving the real property. For a deed to be valid in most states, it must be in writing and contain the following elements: a competent grantor's signature, an identifiable grantee, words of conveyance that show the grantor's intent to convey the property, a legal description of the property, consideration, and delivery to and acceptance by the grantee. Note that a grantor may authorize an attorney in fact to sign a deed on their behalf through a power of attorney. There are different types of deeds, all of which convey title equally well. The differences are only in the promises, if any, that the grantor is willing to make to the grantee. Such promises in a deed are known as covenants or warranties. General warranty deeds include guarantees that obligate the grantor to defend the grantee from all claims against the title. General warranty deeds give the grantee the best possible protection. With a limited warranty deed, the grantor warrants the title only against defects arising during the time that they own the property, and not against defects arising before that time. These are also called special warranty deeds. A quitclaim deed conveys any interest in real property the grantor may have at the time the deed is executed. It makes no warranties whatsoever. These are often used to clear an error or issue with an earlier deed. Acknowledgement occurs when a party signs a document before an authorized official stating it was signed voluntarily, such as when the seller, or grantor, signs a deed. An acknowledgement is not a required element of a valid deed in many states, though it would most likely be required to record the deed. Recording a deed makes its existence clear to third parties as part of the public record. Generally speaking, deeds are not required to be recorded to be valid. Note, however, that recording an invalid deed does not make it valid. Recording a document is a simple process and generally requires a fee to the county recorder's office. In most counties, the document is placed in the public record by being electronically copied to a database. Recording documents allows property owners to defend their estate, right, or interest against third parties claiming a subsequent interest. Although there is no legal requirement to record a real estate document, such as a deed, an unrecorded document is likely to be unenforceable against a third party claiming a subsequent right or interest in the property. Since the public records are available for anyone's inspection, everyone is considered to have constructive notice of the contents of recorded documents even if they do not personally inspect them. If someone examines the documents in the public record, they are said to have actual When conveying real property, the seller is generally expected to deliver marketable title, also known as merchantable title. This is a title that is free and clear from undisclosed encumbrances or other defects that would expose a purchaser to litigation or impede a purchaser's ability to enjoy the property or to later sell the property easily. A title search of the public records, also known as a title examination, is necessary to determine ownership and the quality of the title prior to conveyance. The chain of title is the deeds and other documents transferring title to property from one owner to the next as disclosed in the public record. An abstract of title is a chronological history of title to a property, listing all recorded documents that affect the title. It could include deeds, taxes, special assessments, liens, judgments, mortgages, and other encumbrances that have affected the property, even if they have been removed. A gap or flaw in the chain of title is referred to as a cloud on the title. A suit to quiet title, also called a quiet title action, is a lawsuit to determine and resolve problems of instruments conveying a particular piece of land. It may be required to close any missing links and remove the cloud on the title. Title insurance provides the best evidence of marketable title. It protects lenders and sometimes property owners against lawsuit to disputes over ownership and defects in the title not found in a search of the public records. A title insurance policy states all possible clouds on or problems with the title. Specific defects or issues listed in the title insurance policy, such as known liens, become exceptions to the title insurance policy coverage. Nearly every lender will require title insurance as a condition of financing the purchase of property. This is known as a mortgagee policy. The buyer may also take out an owner's policy. An extended coverage policy covers additional defects in title that may be discovered only through actual inspection or a survey. That concludes our review of forms of ownership and the transfer of title to real property. should be able to name different methods of voluntary and involuntary alienation and identify 3 primary types of deeds. You should also be able to recall the purpose of recording documents in the public record and the importance of being able to convey marketable title. Remember that a number of the topics discussed here may involve the practice of law. As a well-rounded real estate professional, it's important that you understand these concepts, but remember that you should never tell a client how they should take ownership of real property. Instead, advise them to seek out a qualified attorney.